Maritime death claims are among the most complex in the maritime law. It's a patchwork of federal statutes, common law claims, even state statutory wrongful death claims. Now, the general maritime law, non-statutory claim for wrongful death, it starts with some state statutes for wrongful death, but those only apply to their territorial waters. And then the Jones Act supplies statutory causes of action in certain situations. And finally, we had the DOHSA, Death on the High Seas Act, that would cover deaths occurring on the high seas. So we have what's called a non-statutory general maritime law claim for wrongful death. The damages that are recoverable on the general maritime law wrongful death claim are the loss of earnings that the decedent would have had during his lifetime, the loss of domestic services. We also have a loss of society claim and funeral expenses. A seaman's estate, when pursuing a claim for wrongful death against the employer, are limited to pecuniary damages, but if the fatality was caused by someone other than just the employer, perhaps it's a situation where you have a collision at sea. The fatality was the result of the negligence of a third party, that is, someone other than the employer. A non-seafarer or a passenger is typically who we're talking about here. Not a longshoreman, not a harbor worker, not a Jones Act seaman, can recover for negligence. So no longer just unseaworthiness is actionable, and that it can be brought against any party. However, it does matter where the incident occurs. If it's on the high seas, DOHSA will control. But for territorial waters, the estate of the deceased party may rely on the Moragne-Gaudet cause of action, and the damages may be supplemented by state law if there happen to be additional damages and the injury occurred in the state's territorial waters.